Hey there. Today I want to talk to you about the legacy of the COVID-19 pandemic and how it impacted our democratic rights. Now, I know so many people don't want to talk about the pandemic. They want to pretend that it never happened and just move on. And look, I do get the instinct, but if we don't look critically at what happened during those dark years, yes, years, then we are vulnerable to the government doing this again and in a more permanent way. I talk about this issue in my brand new book, which I finally received a hard copy of. This is it. Pandemic Panic. It just arrived today, and you can order it right now on Amazon. Honestly, if you can do me a favor and order the book, I think our democracy depends on it. We need people who have a good understanding and a good record of what actually happened during the pandemic. And that's why I spent so long working on this book and getting it published. So if you can, please do me a favor, order it on Amazon. If you do order it, leave a comment below to let me know, and I would love to say thank you personally. Okay, let me tell you what we need to know about how the government responses to the pandemic impacted our democratic rights. In March 2020, during that haze of the early and surreal weeks of the COVID-19 lockdowns, the federal Liberals were preparing to go to Parliament to table a bill that would grant themselves virtually unlimited sweeping powers to allocate billions of funds and raise taxes without consulting Parliament, up until December 2021. Now, taxation is enumerated as a parliamentary power under the Constitution Act 1867. This is a fundamental responsibility of the legislature, not the executive, and not even the Emergencies Act permits that to be modified. The proposed Trudeau government bill meant many of the measures carried out under these new pandemic powers could be swept in without parliamentary debate and without the elected representatives of Canadians getting a chance to vote for or against these measures. And the proposed bill was actually roundly rejected by all opposition parties, including Andrew Scheer, who was then the Conservative Party leader. And Scheer commented, "We will not give the government unlimited power to raise taxes without parliamentary vote. We will authorize whatever spending measures are justified to respond to the situation, the pandemic, but we will not sign a blank check." Can you imagine the Trudeau government with a blank check in 2020? I don't think I would have liked to live in that world. Now, in the face of widespread uproar, the Trudeau Liberals did back down and withdraw the blank check provisions from this bill. But this early attempt at a power grab in the name of flexibility and public safety, in retrospect, it really was a foreshadowing of the numerous and similar actions to come that undermine democracy and the rule of law in Canada. Now, the rule of law is a bedrock principle of liberal democracy that says that no one in society, neither the governments nor citizens, is above the law, and all are governed by the same law under the same rules, and that's regardless of personal characteristics like your wealth, connections, political power, race, or religion. It means that the rules that govern everyone are stable and predictable. And from the perspective of the rule of law, citizens ought to know in advance the legal rules that they could be held responsible for following. Legal rules shouldn't be changed on an arbitrary whim or applied retroactively, and certain constitutional obligations are binding on everyone. Unfortunately, the requirements of wide-scale emergencies like pandemics have an observable tendency to hollow out the adherence to the rule of law on the basis of flexibility, responsiveness, and swift action. These principles appear to our politicians often to be more important in the moment than the higher level value of the rule of law. And this sentiment is sometimes expressed by the maxim, necessity knows no law. But these sentiments don't form part of our constitutional tradition, and they would seem to severely undermine the authority of our claim to be a constitutional government at all. But during the pandemic, we saw that departures from the basic requirements of the rule of law and democratic accountability in the name of public safety were sadly becoming the rule rather than the exception. Consider, for example, the third wave lockdown measures in Ontario, which were likely enacted with the knowledge that they were unconstitutional. This was a high water point for many, many people in Canada in terms of pandemic misery. It was Friday, April 26, 2021, and many of our friends in the United States were regaling us with stories about how they were returning to normal life owing to, in part, widespread vaccine availability. While most of Canada was, on the other hand, being pummeled by a brutal third wave of the Delta variant of COVID. Now, due to a failure of our own government to either secure timely deliveries or vaccines or scale up our domestic vaccine manufacturing, the COVID vaccines here were not estimated to even be available at least until well into the summer. Herein enter new rounds of lockdowns. So on the afternoon of April 26, in a press conference that was delayed by hours because of last-minute cabinet deliberations, Ontario Premier Doug Ford, flanked by Health Minister Christine Elliott and Solicitor General Sylvia Jones, announced a new set of really draconian measures aimed at what they said was curbing the spread of the virus. These measures included instituting a mandatory stay-at-home order and even closing outdoor playgrounds. From a legal point of view, the gravest worry was that the provincial police had now been given extraordinary powers to randomly stop vehicles and inquire about why you were outside of your house at all. Police, along with bylaw officers, now had the power to demand that citizens provide their home address and explain why they were outside of their house during the stay-at-home order. Now, these measures obviously immediately struck alarm bells among civil rights activists, like those of us at the Canadian Constitution Foundation. In a province of 15 million people, it would seem to be a foregone conclusion that police would necessarily engage in some sort of triaging behavior in how they question individuals outside their homes. And given what we know about police behavior, there were concerns among some people, including us at the CCF, that this would result in the profiling of racialized communities in particular, which already attract a heavier police presence. Now, this is concerning from a civil rights perspective, but reporting at the time also provided strong evidence that the government was even thumbing its nose at the rule of law by ignoring strong signs that there were serious constitutional issues with the regulations for the stay-at-home order and the police enforcement powers. At the time, CBC reports confirmed that Attorney General Doug Downey had even in cabinet flagged the constitutional problems only to be shut down. We'll never know what exactly he said, but it's almost a certainty that some of the concerns raised by us at the Canadian Constitution Foundation and concerns raised by the Canadian Civil Liberties Association, both organizations immediately put out statements that those would have also have been raised by the Attorney General. And in fact, police departments across the province put out their own statements that they wouldn't even use these controversial and likely illegal new powers. But just relying on police not to enforce an illegal regulation is completely unacceptable from the perspective of the rule of law, since the government shouldn't be enacting unconstitutional laws in the first place, knowingly so. The catch-22 of the police measures was that they were short-term regulations. They would likely have expired before a full legal challenge could have been heard by the courts. So it's likely that even if the government had been faced with a legal challenge, they would have expired by the time that challenge was heard, and the government would have then just claimed that the ultimate legal challenge was moot, as they did in countless other COVID-era cases. The Ford government's negligence or bad faith in this case was likely driven in part because it assumed that the courts couldn't hear a challenge in time, and that is just a deeply cynical perspective. Politicians who knowingly enact illegal laws deserve condemnation and I think have lost moral authority to govern. Now, these Ontario carding measures were sadly just one colorful episode in a whole array of pandemic measures that flouted the ordinary operation of the rule of law. Another example was legislatures granting themselves infinitely expanded states of emergency. So we saw this in Ontario as well. At the beginning of the pandemic, Ontario entered a state of emergency under a piece of legislation called the Emergency Management and Civil Protection Act. And under Section 7.0.1 of that legislation, the Premier and the Lieutenant Governor and Council can declare a state of emergency in the province, but it expires after 14 days. There are built-in accountability measures to ensure we're not perpetually governing by a state of emergency. And one of those accountability measures is these automatic sunset clauses. But it seemed like the Ford government was desperate to avoid that accountability. After just a few months of state of emergencies and repeated renewals after these 14-day periods, in the summer of 2020, the Ford government decided to replace the entire function of that emergency legislation with a new act called the Reopening Ontario Act. Under the Reopening Ontario Act, the government defined the COVID-19 state of emergency to be over in Ontario, but at the same time, it transformed the emergency orders made under that legislation into orders under the Reopening Ontario Act and extended many of the powers that they only had because of the emergency legislation, while at the same time eliminating the need for continued legislative approval and without any sunset clauses. In other words, the Reopening Ontario Act allowed the government to extend and retain the bulk of its extraordinary powers through the declaration of emergency under the Emergency Management and Civil Protection Act. The Reopening Ontario Act allowed the government to sidestep the ordinary legislative procedures in enacting extraordinary orders that restrict civil liberties. The new law also empowered the government to override certain key provisions of various collective union agreements, including, especially for nurses and healthcare professionals, and to regulate business. In effect, the Ford government extended its own ability to make COVID-19 health orders without the need for a review process originally set out in that emergency legislation, and repackaged this extension of executive authority in Ontario as an end to the COVID-19 emergency and a plan to reopen the province. But the politics of the Reopening Ontario Act illustrate this general trend of federal and provincial governments concentrating its discretionary power to the executive branch, both the executive cabinet and to bureaucrats as well. And this is all to the detriment of legislative bodies and the electorate. Any opposition to the government's concentration of power was swiftly swept under the rug, and COVID-19 orders continued to be made without crucial legislative oversight. Another example of the provincial government's widening its scope of its executive authority was a piece of legislation in Alberta called Bill 10, the Public Health Emergencies Powers Amendment Act. Now, Bill 10 was introduced, passed, and came into force at lightning speed, only 48 hours in April of 2020. And it was passed when only 21 out of 87 members of Alberta's Legislative Assembly were present to vote on the bill, which was just enough to get quorum. Bill 10 was troubling. Its emergencies powers included two key amendments to the Public Health Act, and both authorized government cabinet ministers to unilaterally create new laws and sidestep the legislature when doing so. The amendments made under Bill 10 in Alberta didn't just grant amazing powers to the minister to make new law unilaterally, it also granted the power to make new law retroactively. It punished citizens' past behaviors for failing to comply with the new law, even though these actions might not have been illegal at the time. This flies in the face of rule of law principles that attempt to make the law stable, predictable, and prospective rather than retroactive. The government of Alberta would eventually walk back these changes in the following year with a new piece of legislation, Bill 66, which was also an amendment to the Public Health Act. But it became apparent very early on in the pandemic that governments would be zigzagging away from the ordinary procedures for devising laws in response to the pandemic. Look, to some extent, I have some sympathy for the impulse because fast-moving emergencies require nimble responses. It was appropriate for the government to act swiftly to ensure, for example, that the Canadian Emergency Response Benefit would be available to Canadians to make sure nobody went without food or shelter in exchange for the government requiring them to stay home and in many cases not work. But the principles of prioritizing expediency above due process went completely haywire during the pandemic, with almost no scrutiny of due proportionality between the gravity of the emergency and its impact on individual rights. We should be really vigilant to ensure that in the future, public health emergencies, or indeed any emergency, doesn't allow government to cut corners without consequences. And one of the ways that we can be vigilant is to learn more and have a record of what happened. So I hope that you will consider buying my new book so that you can do that. And I put a link below to the Amazon page. Another thing that you can do to stay vigilant is to subscribe to our email freedom updates at theccf.ca/freedom updates. And we'll provide regular information to you about our ongoing cases fighting back against government overreach. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.